Hi everyone. Thank you everybody for coming today on a Friday evening on election day. Thank you so much. What we'll do is we'll start right now. Judge Monica will be joining us shortly in 5-10 minutes. But we want to at least start this conversation and start this whole panel today. So good evening. Before I start, I want to thank the Honorable Chief Justice and judges of this court who have allowed us to use this particular area for discussions and deliberations. I also want to like to thank the Indian Law Institute for taking this initiative and organizing these talks. And I want to thank the panelists who've come here, especially taken the time out for this, prepared for this. We are joined with Honorable Mr. Justice Sethi. Lordship was enrolled as an advocate with Bar Council of Punjab and Haryana in the year 1990 as a first-generation lawyer. In a practice stretching over 3 decades, his lordship represented a wide range of institutions, including the Punjab and Haryana High Court and various autonomous bodies. Lordship was elevated as the judge of Punjab and Haryana High Court on 29th October 2018. So this is the formal introduction, but I feel no one in the room would say that he's one of those judges who always has a very positive atmosphere in the courtroom. And whenever you go to the courtroom, you always come out with a smile. And he always encourages us young lawyers to argue to best of our abilities, for which we are grateful. Thank you. And thank you for joining us today. We are also joined with Ekakshra Mahajan. Ekakshra is a dual qualified lawyer who is licensed to practice in the New York State and in India. So after completing her graduation from Symbiosis Law School, Pune, she then went on a full scholarship to Penn State Law. And now she practices mainly in the Punjab and Haryana High Court with focus on bankruptcy, restructuring, and antitrust law. Now we're also joined by Judge Manpreet Singh. Judge Manpreet Singh is a judge in the Harris County Civil Court at Law Number 4. And she's the first Sikh civil court judge in Texas. Prior to her appointment, she was a litigator for over 21 years and has conducted approximately 100 trials. She has served as the board of directors at the American Civil Liberty Union of Texas, the Texas Lyceum, and the Sikh Coalition. Her focus has always been on civil rights and community advocacy. We welcome Judge Manpreet and thank you for her presence.
Thank you for having me.
Yes. So today's topic is a broad comparison on the US and Indian judicial systems. So US and Indian judicial systems are both common law countries. So they have a lot of things that they borrow from each other, especially the Indian Constitution borrows a lot from the US Constitution, but they are also vastly different. And this difference is what we want to understand today. The first difference that is how these two countries are structured and what this system is. So US is a purely federal structure, and India is sort of a hybrid, what we call as a quasi-federal, or some judgments call it as a cooperative federal structure. And I request Justice Sethi to explain what this quasi-federal structure in India is and how it works.
Telling you people that how Indian judicial system works is telling somebody who already knows everything about the law. I will be only reiterating what I know or you all have been taught while getting the law degree. Here in India, the union is the supreme in certain fields. It is not that the states do not have the power, but the constitution has been framed in a manner that certain issues have been given to the state to be decided over the boundary of India. With regard to the certain issues where the states they need to implement some law or to make law to their satisfaction, keeping in with their geographical or other things, the states have been given power. And some are the issues where the powers are concurrent between the state as well as the Union of India. But in case where there are concurrent, in case of divergent view, the union has a better say as compared to the state. The constitution has been framed in such a manner that under Article 246, 3 lists have been prepared. Items have been given in list 1, which are only to be dealt by the government of India, that is the union government. Whatever the issues or the items listed, probably 96 items are there if I know as of now, they are within the domain that the laws, operation of the laws come within the jurisdiction of the government of India, and the states are under obligation to implement the same on the directions given by the government of India. But some are state issues. The state issues, the states have the priority, keeping in view what the legislators want in their respective states to be implemented. Then the government of India does not have any say. The states are independent to adopt and operate those spheres. There are somewhat about 66 items which have been provided there. But some are overlapping. That is the concurrent list, which is the third list, which is the concurrent list called. There, the state has also the power on that issue. The government of India has a power. But the only difference is that in case any law made by the government of India on this side issue and the law by the state on that issue, if they are on the same page, there is no problem. But in case there is a divergent view, the union view will prevail over the state. So we can't say that here the state does not have power or the Union of India has every power to domain the state. No. Everybody has been given a different sphere to operate, because this is why this has been done. Because India is considered as one with having number of states within India. India is not known because Punjab, Haryana have decided to become together to form one India. The India has states. The states, like everybody, you can't say that I am the native of, means I am the citizen of Punjab or the citizen. Citizenship means India. There is no dual citizenship that I am the citizen of Punjab as well as India. No. India is one, divided into different states. Keeping in view the different states, the boundaries have been prepared for each state, keeping in view the parameters subscribed in the Constitution of India. So, the states have the role, but the Union of India has a better role, keeping in view. Now we see the laws, like criminal, civil, they are applicable whole of the India. No state can say, my criminal law will be different than the one by the Haryana, Andhra Pradesh, Delhi, or whatever it could be. The law will be one. The state can't have different laws as compared to certain laws are applicable in whole of the India. States have been given power with regard to certain aspects. But the aspects are such that they are to decide keeping in view. I'll just give you one example, say, like in Punjab, normally the people speak Punjabi, or in Haryana we go Hindi. In the concurrent list, though the state, the education is also within the union, but the states have also been given power that we want to have a Punjabi or Hindi as our one of the language. Union can't object to it. But anything you say that tomorrow one of the states say that no Hindi will be spoken in our state, that can't be done. Because that is our national language, which has a priority to be taken. Anybody wants to speak or anybody wants that it should be our language, the states are bound by that. So Constitution has been framed in a manner that there is one India with different branches. Different branches have not constituted one India. So it is the other way around as compared to America, where different states have come together to form one America. It is not called United States of India, no. India is one with having different states. But there the states are, they have come together that we are the part and we are known as United States of America. There it is, could be, as madam will be telling you, there are different things. The states have a different law. There might be a different law, criminal law in each of the state, but they are bound by their own. So once they have their own law, they are independent within each other. But here you can't say that the Punjab, Haryana or Himachal Pradesh are independent of India. So constitutional framer has said and envisaged one India with different branches, but the branches have also been given power in certain fields to be independent. So this is the basic structure which everybody has been taught, and we have been practicing here also in the court of law. I hope everybody knows it. I only reiterated what you people know.
Thank you. Thank you so much. I think from this there's one difference. India will be a union of states. That's the definition. And I think US has a concept of called dual sovereignty, which I think ma'am will explain.
Yeah, so first of all, thank you so much for having me. It's a great honor to be here in our parents' homeland, and I'm actually even more honored that my parents were here to join me as well. So thank you to our hosts, and thank you also for being a part of this panel with me. So I actually, your question when you started, you said there were so many things that were borrowed from the US when India was being formed. And at first I thought, you guys are more, to me, I thought more British leaning. But then the more you were speaking about your structure and everything, there's actually many parallels that go along with US government that I hear here in India. So I think the difference with India too is every state has its own culture, dialect, food, clothing. I mean, really down to, you can be in the state next to me and I don't understand a word you're saying, right? And we have the same concept within our laws, but not within our culture. So I think that's what makes us the United States of America. We all speak the same language. Obviously we're supposed to not have one religion, but the Christian domination is there for sure. But our government structure is very similar in terms of the court system. So we also have federal government, and that's the main, United States government. When you see the United States Supreme Court, that's the final stage, and that's all a part of federal law. And then we have what we have as the state laws. So the only thing that kind of remotely feels like India to me, in the sense of a different culture, is the state next to Texas is Louisiana. And that was dominated by the French. So even their cuisine is French-based, their laws are still French law. So that's a state I could not practice in next to me. But the state rights are very important as it is now. So federal is our overarching umbrella. Each state kind of governs itself. And that's why you hear, California is more liberal, Texas is more conservative. You hear these generalities based on the state. And the state is who they represent within their constituents themselves. So that does have an effect on how we view crimes, how we view civil area issues, and how we finally determine where they go in terms of how we litigate them. Do I file this case in federal court or do I file it in state court? So, in my state, in Texas, we actually elect our judges, which is how I was able to win our election. Not all the states do that. So even within the court system, California, I'll take that as an example because I was the first elected Sikh judge in America, but California had 9 or 10 after my election that were appointed. So they have a governor who appointed those judges. So then you have these judges that represent these different states in different manners, and you also figure what they are looking for and what they're looking towards. So a lot of similarities in leaving it to the state rights. But the governing body is the United States. And so when you hear our outcries when something changes on a federal level, it's because even if it does come back to the states, and we feel, oh, well, it's in our state law, we feel better, we feel like it's more control, it actually becomes scarier because your state may not be the same as another state. And your morals and values may not align now with the state that you are a resident in. So in that manner, it does become a little bit more worrisome because the current government shift is to have everything moved straight to the states. which makes it a little bit scarier. Of course, it increases our work, which I'm there for. But from the federal point of view, we try to stay united, but it's you know, it's an overarching umbrella. It's the parents.
Thank you. Thank you. Now, so something which is very interesting with respect to rights, especially with respect to civil liberties also in the US, is that your civil liberties, depending on how liberal the state is, depends. If there is no federal structure that governs a specific issue, then it's dependent on the state, and that leads to a lot of conflict between various state residents. So that's a very interesting thing when you start looking at the US constitution system. I think that's a very interesting thing to look at. Now I would like Ekakshara to somehow explain what the difference is and somehow to explain what is practically she feels the difference between these two states once she's practiced in both of these jurisdictions.
Thanks, Rishabh. Just for the benefit of everyone, I know both the things have been covered, the Indian perspective and the US perspective. But I was having a very interesting conversation before we started. So just for everybody, when I went to the States, this was a very novel concept for me. So I'll take the example of New York because I'm only licensed to practice there. So when I went to New York, the federal structure there is in such a way that every single state out there has its own district courts. So the nomenclature is so funny that the New York State's trial court, the lowest level of court, is called the New York Supreme Court. Then it has an appellate court, which is the New York Appellate Court, followed by the New York Court of Appeals, which is technically New York's Supreme Court. So every state within itself has its own appellate body. So vis-a-vis India, for example, when we have, say you have a district court, the appeal goes to the High Court, and then from the High Court it goes to the Supreme Court. In the US, not as a matter of right will every case be dragged to the Supreme Court. Right? So the US Supreme Court, as a federal structure, has 9 judges who sit. These 9 judges sit on each and every case which comes before them, and most of these actually have a substantial question of law, not the kinds that we just draft and put in every single petition. They will only take up those cases wherein, say, the Constitution has to be interpreted, or say, for example, there are 2 states and there are certain disputes which arise within these states. They'll take that up. So that was one of the most significant differences that I saw between India and the United States. One point of similarity that I wanted to point out was that there's a very landmark case out there called Marbury versus Madison. Right? So in Marbury, and I've always drawn a link of that case with the Keshwananda Bharati case. So our entire constitution, I feel that the right that was given to the high courts or the Supreme Court in this country comes from that one particular case which said that Congress cannot alter the fundamental structure of the Constitution. Right? And that's exactly what Marbury versus Madison did in the United States. So though Article 3 of the Constitution of the United States says that there is a federal court which is to be established by the Congress, the fundamental structure of the Constitution will come under judicial review. And please correct me if I'm wrong.
Oh no, so far so great.
Thank you. So that judicial review has been given by the very virtue of the decision that was rendered in Marbury versus Madison. So that was a very interesting contrast. In fact, I wrote a paper on that because I thought that that was a point of similarity. And I'll tell you why that was interesting. You know how we have the Constituent Assembly debates, right? We always go back to the Constituent Assembly debates to know what happened in our Constitution, why certain articles were introduced. There's something called the Federalist Papers. So the founding fathers of the United States, which is Hamilton, Adams, Jay, they wrote these papers to basically explain to the public at large why they were introducing certain articles in the Constitution. So they called the judiciary the weakest branch in the separation of powers. So how you have the executive, the legislature and the judiciary, in India we view all of them equally. That one rung has to always oversee what the other side is doing. So we always look up to the High Court, we always look up to the Supreme Court to just keep our rights intact. However, the founding fathers there themselves said that, say, the judiciary does not have the power of the sword, right? Sword means that they don't have any power over the military. They don't have any power over the finances, the purses. So it is supposed to be the weakest link, and the Congress should be the governing body. Though that, of course, I believe has changed with legal precedents.
Yeah, I was going to say that
Yeah.
may have been their intent initially.
Precisely.
But to us, it's equality based, and it's been manifested that way. And I think that's why this current administration has kind of made our country, has basically put us in fear, because we're thinking if the judiciary isn't there to correct the things that are brought to court, then who can? If there's no checks and balances. Or if the Congress is not, if the executive branch gets so powerful that it overrides Congress, who is it there to keep this checks and balance? So I think it has shaken how we feel as a country at the moment, at least from my perspective, right? Because it's not my party that I find alignment with. So when you think about this, I think over time, it had become that place where we've only been taught in school that it was equal based. So obviously Federalist Paper is people for us who are in the weeds, right? But I think the actual practice of it has always been that. And that's why it's such a jarring thing to say, if the judiciary doesn't say that this is what the law of the land is, then who will? And so that's very scary at this moment in time for us.
And we turn to the high courts. We just
That-
go with writ petitions.
Yes.
And we're
And
like,
it's curious too that you say that too when you started off talking about New York and the way that the court structure is there too. I'm thinking again, going back to this individual state thing. So for Texas, I'm the state court. So our state court, if they think they want to appeal from me, and you're right, it's not a right, unless you're death penalty, criminal, I'm talking separately, I only handle civil cases. So I don't handle any criminal cases. If somebody is not happy with the decision myself or the jury has made, because we have an avid jury system, which I am very fond of. I'm a very big advocate of our jury system. If they're not happy with the result from there, they can appeal it to our Court of Appeals. And then if they don't like that, the Court of Appeals goes to the Supreme Court. For us, the Court of Appeals is a panel of 3, and the same with the Supreme Court. So for us, it's a different system even than New York. And I also want to say, in my introduction, you said Harris County, but Harris County encompasses Houston, Texas, which is the 3rd largest city in America. We're the 3rd largest county. Harris County is the 3rd largest county in America. To put in perspective, if we were a state, out of the 50 states, we would have been the 27th state. That's how big of an area that we represent, or we hear cases from. So my constituents are 5 million people. That's how many people that we're hearing from. So that does make it to where the system does change from city to city and state to state.
I think another thing, whenever we're talking about doing a comparative study between the judicial system in the USA and India, the first thing or the second thing that comes to the mind is just like you said, the jury trials.
Yes.
India is not an alien to the jury trial system. We used to have that system, but it was abolished later on, and USA still follows that system. So maybe if Justice Sethi can start and shed some light on why it was abolished and why it was there in the first place.
Though I am no one to say that why it was abolished, but it is a matter of fact that what happened in one particular case, which led to that everybody thought that the person was guilty, but keeping him with the jury trial and he managed whatever he wanted, they thought that the emotions should not come in with regard to the discharge of the judicial functions, and the actual facts without emotion, only on the basis of the facts and the culpability, it should be seen. Though the human part you can't take away even if the judge is deciding apart from the jury. So when the India witnessed that case, and it was presumed, and he ultimately himself came out that there was some, not I can't say manipulation, but human emotions were played in particular set to get him out of that difficulty, or that he had committed a murder and he was declared innocent. Then keeping in view the structure, constitution, it was decided that it is much better to have a judge-based trial rather than a jury-based trial. Jury-based trial is mainly how you convince the 7 people, even if you have done something wrong, was you actually wrong? But here, even if you have done something wrong, you are wrong, but then we decide up to what extent you are wrong. So that is why the law here and the law in America is different. If I am saying I am compelled to do something, that could be in self-defense. Yes, I can prove it, but that I can prove it on the basis of the facts, not on the basis of the emotion of the 7 or 10 or 12 people saying, in my opinion, he has done this. But if my fact says that I have done and I have proved that it was beyond my control, whatever happened, then the judge is to decide. So that is why, in order to take out the emotions from the trials, because criminal trials are there on the jury, emotions do happen, and now also you see to it that in America, the jury is also selected by the two lawyers representing the other side's defense and the prosecution. But if we decide that who will decide whether I am guilty or not, rather than a person who is judicially minded, that was the preference given in India, which as of now is continuing. I am not saying jury is bad. I am saying that whatever we preferred is going great guns as of now, rather than shifting back to the jury system. That is only that it was. I am not saying every time you manipulate, no. Manipulation is different. But emotions are, yes. My emotions could be different. I say, this man, though he has done, I do not want to harm him. That is my opinion. But somebody sitting next to me says, once he has done something wrong, that is wrong. I am deciding by emotion, she is deciding upon the actual fact. So India decided we will go by the actual facts as compared to the emotions of a particular person, how he or she feels, whether this person, even after doing something, is liable to be. So therefore, we are going by law. Law is one for everyone. You put it before the judge on the basis of the evidence. You can't say that, yes, if somebody comes and says this happened, the judge is bound to take into account. Once he takes into account and then fits into what is required to see whether the person is committed this wrong or not, then the decisions come in. Yes, while deciding the punishment, that man can see to it that to what extent I should give him the punishment, even if he has done something wrong, which was not means beyond control, but could have been avoided. So our system still goes upon a relatively written law. This amounts to violation of law. If this is violated, how much punishment can be given? And the one to be decided on the basis of the evidence is the judge, who is not elected but selected. So this is the difference between India and America.
Thank you so much, Mr. Sethi. So while you were sharing your views, you happened to mention a famous case, the K.M. Nanavati case. I think I can recall a movie that was made on that
Rustam.
case. It was called Rustam. Although as lawyers, we are made to believe never to trust what has been shown in Bollywood. And Judge Monica, you happened to mention that you're a big advocate of the jury in USA and you're still following that system. If you could share a bit how the jury members selected and what steps do you actually take?
Yes.
As Mr. Sethi said, that there's a lot of, when there are a lot of people, there's a lot of play of emotions also. So what goes through their mind and what steps USA is taking?
Yes, I would absolutely love to.
Yes, please.
And can I speak from a place of not being familiar with the jury system? I don't want to feel like I'm just going to start from the basics. Is that okay?
Yes, yes.
Okay. So the Seventh Amendment of our Constitution is our right to a jury trial. So not every case goes to jury trial. So like last year, for example, I closed 7,000 cases in my court. That doesn't mean that I heard 7,000 jury cases. People elect whether they want to have the case sent just to me, where I hear it and I make the determination of law, or if they go to a jury. So let's say you say your case is, you would like to try it in front of a jury because you'd rather have 12 people or 6 people make that determination for what happens. So once that election has been made, I want a jury trial. It's in your petition. We catch it. We put it in a different bucket, and it follows a different track than if you have what we call a bench trial. That's just when you're trying it to me directly. Once it goes into the jury trial pool, we select people from our greater county area. They put a summons in the mail, and it's on a rotating random basis. So if you have the benefit of our citizenship, and you have the benefit of our driving on our roadways, you have the benefit of our county, then this is a part of the service back to your government and your country. So those people answer it, and what we do is we have what we call a jury pool. So let's say for Harris County, they bring 500 people in that morning at 8 in the morning. So 8 in the morning, 10 in the morning, 1 in the morning. Myself as a judge, the day before, I'll say at noon, I'll say I'm going to start a jury trial tomorrow, and my jury trial is going to start at 9 o'clock. I would like to have 24 people to choose from. And so I bring in, and I'm going to use the 24 number because let's say we're taking out the 6 juror members for my trial. So I'll say I'll need 24 members of the general public to come in. They will randomly give me a pool of 24 people, and they'll hand out numbers. Those people come into my courtroom. I will do a brief introduction as to the privilege it is for them to be a juror in that moment. Now, before they've even walked into my courtroom, I have ruled on all issues of law. I have ruled on all evidence that will come into the presentation of the case, eliminating the emotion from it. So I will not let pictures that invoke emotion come in. I don't let testimony that invokes emotion come in. I will keep them on. It is my job to be the referee of the case, to keep the case in line and guide them with the law. Then it is the job of the advocate, and that's why I'm such a big proponent of this, is because the advocate gets to advocate, and they get to convince their case to these people that they're going to show their ultimate jury trial to. And what's important to me, and what I tell the jurors are, back in the times when the Roman Empire was going, they'd go to the Colosseum, they would fight it out in the middle, and the crowd would say, this is the person who won, or that is the person. It is the same or similar type of concept. You're putting 6 strangers together who are determining these 2 parties who have a bona fide conflict. They have a conflict that by questions of law, they have a question of law that I could not eliminate. So nothing that I can eliminate, if I can eliminate the question of law, it doesn't go to the jury. The only thing that the jury hears is a question of fact. So they don't have anything to do when it comes to the law portion of it. And once we do what we call voir dire, where we pick out the 6 people from the 24 people, both sides speak, the plaintiff or the defendant, the prosecutor or the public defender or defense attorney, they both are given equal time. So let's say I give 45 minutes to the plaintiff, I'm going to give 45 minutes to the defense. They're able to ask questions that eliminate the ability for the juror to serve. So if I ask you a question, I'm going to do a case about my client's mother who has passed away in a hospital. I want to know if your mother has passed away in a hospital. I will eliminate people who have a personal connection to the facts of my case because they are determining the facts of the case, not the law. So I want to get rid of the people who do not belong on my jury. The remainder leftovers of the 6 people are now said to be fair and impartial to a certain extent because I've gotten rid of their biases that I can control. Once those people are in what we call the jury box, we present the entire case to them. And again, that's while people are speaking, attorneys will object, I will rule on the objections as it happens. Evidence may come in that's new, we'll send the jury out. There's things that we go back and forth with, me and the attorneys, then the jury comes in. We keep the jury very sterile in terms of what they hear. And the things that they hear is said to be tested in the courtroom, meaning an expert has gone through it. My eyes have gone through it. Anything that I've given them has been through my judgment whether or not they've heard it. So once they have done the case, closing arguments, cross-examination, everything, they go and deliberate on a verdict. And the way they deliberate on a verdict is very deliberate. I will give them what we call a charge of court. And in the charge of court, the law is written. So I have now determined this attorney did not prove their case. Negligence cannot come in to this charge, and the jury will not determine whether there's negligence because I have determined you didn't prove your case, negligence is out. This next element, you did prove this element. This will go to the jury, and this will be on the charge, and the jury will figure this out. So the facts that they've heard that have been presented, I have now given them the law to apply it. So it is a government for the people, by the people, in its truest form. And that's how we work on the jury being very much a part of our system. And I tell our citizens that. I say, look, you can elect your congressperson, you elect your president, they go to DC, they go to your capital in the state that you live in. But judicial system is the only system that they have an active role in when they come and they are a part of the jury trials. So it's not, and there's a big difference. I mean, I hear bench trials, I hear trials all the time that are done to me. I mean, our personal biases, even as pure as we are, they come in as well. And so to have the benefit of having 6 other people guide the decision makes a difference. Now also remember this, if those other people, 6 or 12 juror members come back, and I believe that the evidence did not support based off of what I heard, I can undo everything. So it's not one of those things where you are just, this is it. One thing that we have is we have an appellate process, we have a review process. Once the trial is done, they still come back before me. It's done for the jurors, but you come back and say, okay, this is what they found. I would like this dollar amount, I want this, or I want this sentence, or I want that. And I can say, I didn't really think that was it. I'm gonna reduce it to this. So that is there still. The checks and balances of the judge is that it's very heavily handed, guided by the judge. And that matters the most. So from an advocate perspective, every advocate wants to know whose judge is going before. What is that judge like? What type of evidence do they allow? They want to know how the judge thinks because it even affects the jury trial as much as it affects the bench trial.
Thank you so much, Judge Monica. Also, when we were discussing the structure, you said there's not every case that goes into appeal. So if someone, when he's being tried, he or she is not happy with the verdict of the jury, so what recourse or what remedy of appeal do they have?
So then they have 2 immediate ones.
Okay.
Immediate one is they come to me and they say, I want a new trial. I thought that you let this information in erroneously, and because of it, you've altered the decision. The jury would have done something differently. There's other methodologies. Motion for new trial. They want a new trial. That's one thing. The same thing I was saying, judgment notwithstanding verdict. Other than what the verdict said, we want you to reverse what they did. That's another. These are all methodologies still within my control, and I only have a control of over a set amount of days. And after that, they can go and appeal it to the Court of Appeals. So I call them my teachers. They grade my papers. They take the transcript from the entire trial, and they read over the entire transcript, and they say, okay, what this judge did was fine. Sorry, this is correct. Or what she did was wrong. Take it back to her, and you go do it all over again. Or she did it wrong, and here's the right answer. Those are the 3 options that we get from the Court of Appeals. And then, of course, if they're not happy with that, then they can go to the Supreme Court.
And whenever there's a trial happening in the jury, so is there a specific time within which the jury has to give their verdict once everything is
No. So very much, we revere our jury system. So just like you guys are respectful when a judge walks in a courtroom, everybody walks in, stands up. We stand up with the jury. We do everything to make sure that they're comfortable. They are now our judge and jury. So when they get the verdict time and deliberation time, I always tell them, I say, listen, you tell me when you're ready. If you need me to order dinner, which, here in India, you guys are very hospitable. It's not a big deal. For us, it's a big deal. We're taking care of people everybody needs to know, right? We gave you free snacks. So, they say we want to stay for dinner. We want to keep going. They keep going. They say we want to come back at 8. I'm coming back at 8. Whatever, it's on their schedule. Once the deliberation happens, it's on their schedule. and we do whatever it is to make it easier for them to get to the decision that they need.
Thank you. Ikaksha, you have been to New York, you have a license to practice in New York. Have you ever experienced, when you've done a trial, what is your general view on the jury trial and the abolition of the system in India? I would just like to know.
So see, I haven't really witnessed a jury trial, so it was a very interesting perspective for me as well to hear the Indian side of it and now the US side of it. But I just want to add very quickly two things that I felt while hearing this conversation. And one of that was that, I understand when you said that, emotions, etc., that those are of course taken care of. And that's very interesting to note because whatever we've seen the O.J. Simpson trial, right?
Yes.
We've seen
And that would have been enough to get rid of the jury system for us too. How much it divided up our country, yes, I get that.
We've seen that, and we've seen George Floyd very
Yes.
recently. So and of course this is mainstream media, and which is why KM Nanavati also, that led to the abolition, because there might have been jury trials, like you said, where biases did not play. But then because it got so much media attention, that it just led to that
Of course.
abolition. So just looking at that, it just feels that a jury system might not be the most effective system for a country like India, especially since we're always crying about pendency and given our population. And for something to be efficient in our country, like you said, if it goes back and you do declare that to be a mistrial, for a case that was argued at length, say for months altogether, to be argued again, I don't feel like our system can handle that.
I tend to agree, knowing how long some of these cases take in your system, right?
Perhaps Justice Sethi can add to it because, like.
But you see to it now, the only thing is you have just got that. What is pendency? Pendency is that we are not able to decide. In America, before everything goes to a judge, it goes before the lawyers to decide whether there is something or not. Here, the first thing comes before the judge, whether something wrong has happened or not. Now, keeping in view the awareness, I'll just say awareness among the people about their right. Earlier, keeping in view the society and the dominance, people used to tend to forget, no, let it happen, I do not want. But now at the slightest variable, the people tend to come to the court for even anything you name it, they want that it should be given to them. That is the problem. Now, how Indian courts behave. Indian courts behave means that people will decide as to how their cases are to be dealt with. In America, when you file a case, it does not come before a judge immediately on the next day. And here in India, it comes within 2 hours in the district court for the judge to decide what to do in it or not. The moment he issues notice or she issues notice, then the other party is to be served. There the procedure is different. They are much modern, saying this amounts to service, but where we see here, though we are changing now that the WhatsApp and the other thing means service, till a person comes and raises his hand, I am the respondent, we say he is not served. So that is the difference. Population here is of a different society. And the process of dealing with those is entirely different. I don't think so that ma'am will be dealing with 150 cases a day on a particular given point of time, on any day. And here, the High Court judge deals with 150 to 200 cases every day, and he is supposed to have read them thoroughly to even decide the same. And that without the help of jury. So, the system in India is different. Though pendency is growing, but we see that the people have become more interested about their rights. That is why it is growing. Yes, we do not have enough people, but sir, everything depends upon the infrastructure. We want that there should be more judges. Yes, everybody wants. But do we have a place to keep them? We do not have even the courtrooms. If we go to a district court, the people are sitting in a tiny room of 8 by 8. And if you make a judge who is a class 1 officer who is to decide about your litigation, the moment he enters says that this is my courtroom, how will I work? Half of his zeal to work goes. But still, in India, you see the number of cases decided. Ignore the pendency. I am sure we might not be less than in America how much they decide in a particular year. In High Court, every day you go and open, we decide round about 2,500 cases. 53 people deciding about 2,000 cases every day. It is a big achievement. But we only look how much he has not decided. That is the problem. We are humans. You just put it in the post box that this is my grievance, please decide. And rest everything is to be done by us. Sometimes it becomes problem. Yes, humanly it is not possible in 300 minutes to decide 200 cases. And that too after giving reasonable opportunity of hearing to both the sides. But we are doing whatever we can. And the pendency, please do not go on this that the pendency is increasing. See from the other side, the people are becoming more aware of their rights. Right?
Imagine now there's a jury trial and there's a mistrial because there isn't a unanimous decision and it goes back.
No, I'll just say that, as ma'am has said, that yes, it can be. It is not that in India it is not. It is in India, yes, there is a review. But that has only for a specific reason that in case something was there before you and you ignored it, or something was there before you, you interpreted the fact in a wrong manner. Yes, that could be. But that will not take away that yes, in case somebody tells me that you were wrong, I see and yes, I am wrong, I will decide within the next 5 minutes. But madam will have to call a new jury to decide that question again.
That's also not always the case. I mean, I know it sounds like I said that's one of the options. If it's like completely, everything has gone in such a way that this one decision that I made somehow changed the entire course of it. Now, they can also use that one opportunity to say, here's a commentary on it. Look, she made this decision. It was wrong, but it didn't affect the outcome. Let's leave it as is. Or it was wrong, and here's the alternate. You don't have to call in a whole nother jury trial. But this distinction that you brought up is very important to me, that the attorneys do not go through and hear the cases before they come. He's absolutely right. I can have the case filed. I mean, I've been in India for 2 weeks. I don't know how many thousands of cases have been filed while I've been here, but I won't see them till next year, or not even next year, earlier than that, obviously in the next few months, but I don't even know what's happening with those cases because I'm not the first review. People only come to me. Sometimes I feel, I'm already a mother of 2 boys, but sometimes I feel like I'm a mother in the courtroom too. People only come to us when they have a dispute amongst each other. That's it. He's not giving me this paper or she's not giving me this deposition. That's when they come to us. They really don't come to us to say, does this case, yes, this case doesn't have merit after some time or whatever else, but not initially. That's like you're almost like the intake department, and that's quite the load. We have that already set because from the civil perspective, no attorney is going to take a case that's not going to make them money. And from the criminal perspective, nobody's going to take the case if the district attorney hasn't accepted the charges. So then those kind of take care of themselves, and then you only come before us when it's time to actually have something to come before us for.
But here in India, everybody depends upon us to decide rather than deciding
Yes.
in between.
Very interestingly, Justice Sethi said that we put a post in a post box post box, and everything is there for people. So very interesting feature of our Indian constitution is about a free legal aid. Article 39 says about that. And furthermore, there are many public interest litigations which have come out of a post given by an anonymous person or out of a newspaper cutting that turns to be in a very great public ruling by a courtrooms, by a Supreme Court, by a High Court. So I would like Mr. Justice Sethi to enlighten on this aspect also.
Look, what in India is, every law is a written law. The judges are not supposed to make a law except the Supreme Court under Article 142. Whatever they say becomes law. But in India, the primary duty of the judge is to see that there is a violation of the written law or not. In case there is none, even if a person you think has done something wrong, you can't touch them. So what we do is the interpretation of the law to find out whether the same has been violated or not. Now, as Madam has said, that the checks and balances, we are not for checks and balances. Checks and balances means that somebody does this, whether he has done this right or wrong, the judiciary is to see. No. Judiciary is not to comment upon the legislation, which is the competence of the legislators. We have only to see in case that legislation was beyond their competence to do that. But still, now what is public interest? Public interest is that somebody who is not personally prejudiced by it, but brings to the notice that in my opinion something is being violated, kindly look into it. That is called public interest because he has come for the interest of everyone, not his personal interest. The moment it is personal, PIL goes. So then the courts have been given power. Yes, he has brought something to our notice. Let's look into it whether he has a genuine concern or not. And that too genuine concern is in relation to the written law. In case the written law is not violated, the grievance that written law is causing prejudice is not to be accepted. Therefore, it is not a case here is checks, balances, no. We have to decide the culpability or the otherwise on the basis of what the Constitution and any law framed under the Constitution by the competent legislators is there. Public interest litigation we have grown. Grown means earlier it was not the part of the Indian society. It says, who are you? We say, tu kaun. That if you are not bothered, out. We are not here to decide. Somebody who is prejudiced will come. But now we have grown saying that in case somebody who is prejudiced is not coming forward, which is giving liberty to somebody to violate, why not to stop that violation by putting our foot down? That is called public interest litigation. And the scope of the public interest litigation is, in my opinion, as of now, is a fishing inquiry. Because somebody tells you, you do not know whether he is right or wrong. He only files an application saying, Harsimran Singh Sethi is not sitting from 10 to 4. Somebody will send me, kindly go and look whether he is sitting from 10 to 4 or not. Because he has not mentioned that on Sunday or a Monday or today Friday, he was sitting from which time to which time. So public interest litigation is necessary. Because you can't think that everybody who is vigilant about the law, though not prejudiced or prejudice, will come to the court. Like I'll just say, public interest laws, you see the brick kilns, the people used to work without any money. They used to be given 1,000 and then for rest of the life. But somebody vigilant came, they can't come because they do not know what they are being subjected to. So you intervene because this is not possible. Yes, the courts come in that this is not possible, you are violating the law. It is better used for the people who can't agitate for their rights. And it is now being used for the people who are too powerful to hide. So either it is used for the topmost or who is at the grassroots level. But public interest litigation is very good and should be explored, but with the cautions. Public interest, in my opinion, here, the counsel, you do charge for the public interest litigation, but the public interest litigation means that it is in his interest also, who is arguing for somebody else also. So this is the public interest litigation which we should do.
From this session, we are very enlightened, and we have very thankful to Justice Sethi, Kaksha ma'am, and Justice Monica ma'am for enlightening us. And if anyone is having a question, so kindly ask.
I have one question to Ms. Monica and to Honorable Mr. Justice Sethi also. That how are judges appointed in the US? Because Justice Sethi made the remark that the judges are elected.
Not I made remark, I only accepted what she said.
These are selected in India. So what are your views with regard to the appointment in the US? And I would like to Mr. Justice Sethi to comment on that with regard to the Indian system.
So we have, every state has its own system. So in Texas, it's election based. So I'm going to contrast that to California. California is appointment based. So that's a different state. They have a different version of it. So for us, there's pros and cons to election and appointment. I mean, the pro to election is that you can actually become a judge by just talking to the public, getting there, and meeting the community that you want to represent, right? The appointment process we have, and there are some benefits in that because then you have them selected by a legal arena or whatever else. The negative to me in an appointment system is it's who you know, and it's who's going to become there because of who you know, right? And of course, it benefits us too. As I mentioned, we've got 10 new Sikh judges that have been appointed by Gavin Newsom, who's our governor in California. He's obviously somebody who aligns with us to be able to pull up Sikh judges there, right? My governor, Governor Abbott, is a Republican who is never going to do anything to diversify the bench. So he would never appoint me, nor anybody who looked like me. So then I think it's a bad system. An election, the con is that you have people, 5 million people voting for you who don't have a clue as to who you are because they have to research every single person, and Americans are going to be lazy, just like Indians are going to be lazy. They're not going to always research before they have their elections. So pros and cons to both, but both are available depending on what state you're in and how the system governs itself.
In India, we don't go by the caste. We don't go by the religion. We go by the, inverted commas, the competency. Now, how the judges are appointed, you all know that because you all are the contenders. In India, the judges start from the districts and the magistrates are appointed. Everybody who is an Indian citizen is given a chance to compete and show the capability that he or she can do the best for the one of the pillar which we watch for is the justice system. Whosoever is found capable is appointed, irrespective, all can be from one caste or one can't be from any caste. So we do not vote or we do not elect them, we select them. So selection is the primarily based, keeping in view your capabilities adjudged by experts in their fields, whether you will be a good person or not. Now in the superior judiciary, the same is that they come in the same way by selection from the lawyers, and anybody who is competent or keen to compete can get selected. But in the high courts, it's a different view. Though somebody says that it is election, but we still, because we have been the one, we say we are selected. Keeping in view, yes, because there are too many people here. And I am the one least to say that I was the most competent to be appointed. No, but I say I was the luckiest one to be picked up and brought here. So the role of the government comes, but that comes at the end when you are picked up. Whether the person is, we say again, competent enough to appoint. Like ma'am said that in California, 6 judges have been appointed. We don't go by that. We say that in case 7 people are appointed or are to be appointed, we choose the best 7. It could be anyone.
No, they just happened to be sick, I should say. There was also a number of other ones that were, but my point is opportunity.
So now we change. We thought that 7 best 6 people who are
that's not
that
correct.
is how.
But yeah, no, it's the same. That they also have.
But-
it
For
but-
the elections, anyone can go, or the person with the law degree?
anybody. That's the.
Anybody.
Yes.
That's why they say.
So you are also eligible there.
Not citizen.
So go to meet Agashra, get the license and go there.
It's the same people who. So when my governor is elected for my state, I'm on that ballot. The presidential cycle just ended where the president was elected. There were a number of judges on that ballot as well. So it just depends on which cycle you're on, because half the courts are on one cycle and half the courts are on another cycle, that it does that. But the majority of our system is through appointment as well. And yeah, just to be clear, I mean, I think Gavin Newsom did over 150 of them. They just happened to be 10 that were sick. Just the point to me in that point is that when you have a governor that is encompassing of different values and another one that's encompassing of different values, you have a different result. And that's why that can, to me, be a minus because of my state, but can be a plus because of another state. And that's the difference there.
And secondly, you see that there are 3 pillars: executive, political, and judicial.
Yeah.
The High Court judge is the one who clears all the 3 hurdles to be appointed. First is the judicial, then is the political, and then is the executive. When all 3 agrees, then only you can be sitting here having this conversation. Otherwise, it is very difficult.
As we come to the conclusion of this enlightening conference, it is my privilege to extend a heartful vote of thanks to the judges, panelists, the insightful and meaningful discourse delivered by the honorable judges have been profoundly enriching and informative, offering us valuable perspective and knowledge. We are deeply grateful to Ms. Akaksha for sharing her wisdom and experience. Your presence and contributions have been invaluable. We are also thankful to Suvi sir for organizing all this. So thank you everyone for being here. Thank you.
Thank you.
Very
Nice to
nice
meet you.
meeting you.
Nice.